And if people have questions, we're happy to take them.
When you're talking about, you're saying the proposed change in the salary threshold, so does that mean it's not, I thought it was going to happen next year for sure, that anyone under that limit would have to get overtime from now on. Is that still proposed? It's not for sure that's what's going to happen?
Well, I think it's proposed and that it hasn't actually gone into effect yet, but I mean, it's coming. It's no doubt that it's coming down the road next year. Yeah.
Yeah, they threw it out there, but just by the way, the federal limits that I had out there of $50,000+, even California and New York don't have dollars that high. Their standards are around $35,000, $36,000, something there. So the federal government has thrown out a number that even California says is too ridiculous. So anytime California tells you that your law is over the top, you know that the federal government is really reaching with that number. So I would expect it's going to come down, the salary number, but how far, we don't know.
Yeah.
I have a question about the Fair Credit Reporting Act and whether you've seen any guidance on when you have the background check. You see an arrest for one thing and a conviction for another, and probably as a result of a plea deal, and how to consider that in a hiring or firing situation.
You know, from the Fair Credit Reporting Act, the Fair Credit Reporting Act really doesn't dictate the kind of what you do with the information. It's more of the nuts and bolts of how you get the information and how you get your consent from an employee to engage in the background check. In terms of the kind of what you do with the information, if it's an arrest and a plea and maybe a conviction with a plea, for example, you unfortunately need to go through this individualized assessment that the EEOC in their criminal background check guidance says you have to go through. So you can't just look at the conviction and say, you know, we're going to disqualify. You need to, you know, sit down with the applicant. You need to talk through, you know, what the arrest was, what the conviction was, you know, how long ago it happened, what happened, and then figure out, make a determination. And my guess is with an educational institution, it's probably going to be a pretty easy determination to say there's just a certain set of felonies that, A, by law we can't hire, but B, I just frankly don't want somebody who's done something like this. You know, so the EEOC says, for example, you should almost never use arrest records because it's not proof of anything. It's just that somebody was arrested. You can, however, use the underlying facts that led to the arrest to maybe disqualify someone from employment. And so, and the example they give in their enforcement guidance is a school. So the example they give is a school principal who is accused of and arrested for a sex offense with a child, right? Just arrested, no conviction, and the school fires the principal. Is that legal or illegal? And the EEOC says, if you're just using the fact of an arrest, then it's illegal because it doesn't prove anything. But if you're relying on the nature of the employment and the underlying conduct that led to the arrest, a principal accused of molesting a child, well, God, no school, whether it's true or not, no parent's going to send their kids to that school if they know that the school is employing someone who is even accused of, you know, I'm not bringing my kid into Subway if Jared's serving the sandwiches there, right? You're just not going to, you're not going to send your kids to that school if the principal is accused, you know, forget about the conviction. So, but you need to really, they really want you to dig into the facts of the offense and figure out whether those facts justify disqualifying the individual.
But by the way, what we're talking about for the most part here today, they're not truly illegal acts. There's no law that's been passed that says that you have to do this. This is rulemaking by these administrative agencies. So you can ignore their rules to your peril if you want to face a lawsuit from the EEOC, and you can roll the dice and hope that they're not going to come after your little business because they've got bigger fish to fry. But this is not a law. This is a rulemaking process by the EEOC, and you just have to decide whether you can abide by their rules. But if you don't, and they come after you.
Yeah. My understanding in the past is that if somebody understand now that you have to notify OSHA if one person is admitted to the hospital, because you turn on a jacket.
Depends on the nature of the injury. I mean, it wasn't great with certain conditions, but again, if somebody pokes their eye out or something like that, one person, that gets covered. If it's a respiratory issue and 3 get hit, you've got to report it. It's going to be, any hospitalization is going to get reported under your OSHA regardless. So notifying OSHA, dealing with OSHA is like the tree that falls in the woods when no one's around and making noise. OSHA will catch you if they catch you with reporting stuff like that. So filling out your OSHA 300 logs accurately, that's important, and they will find out about it if they do an audit of your 300 logs or if somebody reports. So I know lots of employers out there who, I don't want to say ignore the law or ignore the recommended reporting, but they certainly creatively report it. So if one employee goes in on one day and another employee goes in the same thing 2 days later, is that the same instance? There's gameplay out there is what I'm telling you, but OSHA will report it if they audit your record.
Thank you all very much for coming. We really appreciate it.